Thank you so much, Chair Lady. I know you hate it when I call you Chair Lady, but you are the Chair Lady. Thank you so much. I would love to hand over to Mr. Rosen. Mr. Rosen is responsible for the Faculty of Law Clinic. He is also in charge of the legal behemoth in the Faculty of Law at the University of the Free State. Mr. Rosen, I would just love it if you gave the junior students, a brief explanation of where we are going with Moot Court, what is going to happen with Moot Court in the future, and about the plans that we are intending to endeavor, or you are intending to endeavor on with the Moot Court. Mr. Rosen, over to you. Just kindly a brief introduction. Please do that for me, Mr. Rosen.
All right. Thank you very much for that warm introduction. As mentioned, my name is Christopher Rosen. I'm an attorney here at the UFS Law Clinic, and I coordinate Moot Courts here at the university. So the plan is currently to centralize all of the Moot Courts. Remember that the university participates in quite a number of Moot Courts, some of them local and some of them international. Obviously, the last year has been very difficult. There's been no travel, and most of the Moot Courts have been taking place, let's say virtually, which has presented quite a new dynamic to students. I think when the candidate attorneys, when Karita and Arman speak, they'll also probably speak to you about how interesting it is to have virtual court appearances these days, which is, a brand new sort of instance in South African law where all of our court appearances are starting to happen virtually now, and the Moot Courts are taking the same position. So what we're planning on doing is to start centralizing Moot Courts at the university, picking students, both junior and senior, right at the beginning of the year, and then training a sort of cohort of each group of students throughout the year, and then picking students to partake in different Moot Courts from those specific cohorts. So what this does is it creates a bit of continuation with the students. And what it also does is it empowers the students. Even if you don't participate in a Moot Court, you can still learn the important skills that Moot Court teaches you once you start participating in the training and so forth. So as you all know as well, very soon we are going to be getting our first cohort of students who are doing Moot Court as a compulsory or an elective subject between that and academic writing in a lot of your subjects. And this is one of the most powerful points of a Moot Court is, I also took part in Moot Court when I was a student, and I was also a student and a candidate attorney and so forth. But what I found is that it's very difficult to learn a subject on someone else's terms. You sort of get a guide, you get chapters, and you learn for tests. And although, a lot of the subjects interested me, one of the big issues is there's a lot of subjects that simply don't interest you, and that it becomes extremely difficult to, learn that subject or you get a grasp of that subject. And this is one of the great things about Moot Court is if you pick, if you're interested in human rights law, insolvency law, international arbitration, or, you're just interested in learning litigation skills, Moot Court is really one of the best ways that you can learn this because, you are completely self-driven in the way that you learn. So that means that, it's up to you to go and do all of these steps, identify facts, identify issues, identify areas of law. And the only way you can really do this is, by practicing it over and over and over again. And the last thing that I just want to mention, at least with the plan going forward, is that we must remember that there's no other real subject that teaches students practical experience. And I understand that, the legal degree is a very wide degree. You need to prepare people for compliance and regulation, advice, legal advising positions. There's so many jobs for students with LLBs these days that we sort of forget that litigation and preparing court documents are a big part of what we do on every single, at least most of us. If you go into litigation or you become a candidate attorney, you are going to have to see the inside of a court one day, or you are going to be expected to start drafting applications. And so the idea is that with these Moot Courts, we're going to teach you these essential skills that, how to plead properly, how to argue, how to be persuasive, how to do research, how to do argumentation, oral and writing argumentation. And that forms a big part of the graduate attributes that the university is concentrating on these days. Because obviously when you guys graduate, we want you to graduate and walk into a legal field, with some confidence in yourself that all you need to do is just learn certain small facts, but you are comfortable in a court and you are comfortable speaking, you are comfortable, defending your position and being in difficult situations. So that's all I have to say about the future of Moot, at least at the University of the Free State. Maybe the last thing I want to say is that it is my plan in the next 2 years to win a local Moot and at least place in the finals for international Moot court, which would be a big step, one that the university has not taken in quite a long time. Besides, obviously, the juniors in the Kofsin Moot court, because our students just happen to always be in the preliminaries and the finals in the Kofsin Moot court, at least in my experience in the last 5 years. So then I just want to mention a few things that I think are important for students to know. First of all, that you'll see that a court setting is quite a difficult setting, and many of your clients one day are scared, very scared of that situation. And of course, a court is a scary place, but one of the things that Moot court teaches you is how to be comfortable in that space and how to keep the ball rolling. How to continue being confident, how to answer difficult questions, how to speak your way out of difficult situations and justify and persuade. I also think that another point that students need to realize is that, and I suppose the candidate attorneys, and if you speak to any of the previous mooties who have gone into practice, this is a really important one, is that you get an opportunity to network with your students, with fellow students, but also with members of the profession. So often students get opportunities to interact with High Court, Supreme Court of Appeal, and Constitutional Court judges if you're lucky enough. Like I said, the Kofsin Moot Court used to happen in the Supreme Court of Appeal. You also get to interact with advocates and senior attorneys, which is a great way to sort of start building up a network, so that one day when you start applying to do your article somewhere, it's great to already have someone in the firm that's already on your CV. And Moot court is really a way to introduce yourself to someone and also to show them what you're potentially capable of, in the next 2, 3, 4, 5 years. There's also something that, let me say, you don't get warned about when, at least I wasn't warned about it when I started my LLB, is that if you think being a student is difficult work, wait until you get into practice one day. There's very little time for, a social life, and the responsibilities are quite heavy when they're on you. And remember that a lot of your clients are sort of paying you, or at least relying on you, to get what they want at the end of the day. And so this takes you need to learn the hard work, and you need to learn the dedication, sticking things through from the beginning to the end. But also, you should never learn these things in isolation. And a great way to improve your own thinking and to, get what your client wants in the end of the day is to speak to others, run your ideas by them, let them criticize your ideas constructively. It's really, we like to grow in silos, and the biggest thing these days is that we have social media. So, you can very quickly publish something. And, in my experience, that is maybe not the best thing in the world, especially not if you're an attorney or, any form of legal practitioner. So speaking to your friends and running ideas and arguments and discussions by them first, really helps you think, oh, okay, I should have thought of that previously, or maybe I shouldn't do this, or maybe I shouldn't go forward. And then, I wish you all the best of luck. I look forward to seeing you not just in the junior moot courts, but also then one day in the senior moot courts. Obviously, if you take part in the junior moot courts, that's your first step towards taking part in the senior moot courts. And, I can attest to the fact that the level of arguments and the level of quality that you get to is really, you compete against some of the best universities in this country, but also some of the best universities in the world if you get through to the international senior moots. So, I want you guys to consider this as a sort of foundation. I don't want students to take part in the junior moot and then think, oh, okay, I've done what I've needed to do. Because, this is ongoing learning the entire time. And you have this curriculum in front of you, and if you pass all of those subjects, it's going to be good, and you'll get a degree at the end of the day. But, we don't want you to just get a degree. We want to put you in a position where you are ready to enter the practice. And, if you are ready to run your own firm one day, so be it. And then at least you know the basics, so that you can enter into these so that you can really build a professional career as you please. All right. Thank you very much.
Thank you so much, Mr. Rossen, for the words of encouragement. I think the Moot Court in the University of the future of the Moot Court in the University of the Free State is looking so bright. I couldn't find my sunglasses. That's how bright it looks. So I should have put on my sunglasses. But anyway, thank you so much, Mr. Wilson, for the words of encouragement. And I love the fact that you mentioned that this is just the foundation. So for junior students, you need to build on this. And guys, did you hear the challenge that Mr. Rossen has imposed on us? He said that for the past 5 years, the junior students have been making it to the finals of the Kofsi Moot. So we have a challenge that we need to take on. Our next speaker on the program is Ms. Karita Visser. Ms. Karita Visser will be speaking on legal research and legal writing. Ms. Karita, I know you are going to share your what is this? Thank you so much. I know you're going to share your slides with us.
Yes. Let's see if I can do. Should I try, or are you going to have to set something first, like change a setting or something?
Please try.
Let's see. Can you see my slides?
Yes, I can see the PowerPoint presentation on my side. Can everyone see the PowerPoint presentation? Can you guys see it? Can just one person indicate? Toshanti, can you see the slides? Okay. Ms. Karita, you may commence with your presentation.
Thank you. I just see my laptop is a bit slow. I'll just give it a second. Afternoon, everyone. Thank you so much for making time to join us online. It would have been great to see you in person, but this is the new way of work, as we are putting it. I'm going to put on a timer here because you will notice from Harman surely as well, when you're in the litigation department, you learn to really enjoy talking. Okay, so I'm putting on a timer here. I have 15 minutes, and that's also a good way for you to approach moot court preparation and the actual arguing is to always check the time. Okay, great. So I'm quickly going to run through the basics of legal research and legal writing. I just want to make sure you can hear me. If there's any technical glitches, please just holler. Okay. So before I get to actual practical points, I just want to start by saying I kind of prepped a PowerPoint to be aimed at first-year students who haven't mooted before. So perhaps I'm going to just repeat a bunch of stuff you already know, and I apologize if that's the case. It's just always a good time to get back to the basics. So I'm just going to assume you know what a moot court is. It is a hypothetical set of cases that you will argue in front of a judge. Usually, it's a hypothetical set of facts, but you use real life laws and real life acts and real life case law to make your argument. So all moot courts require oral arguments, but some moot courts also requires you to hand in written arguments, which usually it's called the heads of argument. That's what we use in our courts in South Africa, or memorials. That's usually for international moot court competitions. Either way, you need to know how to do legal research, and you need to know how to structure your argument in a logical manner. So I think that my presentation today will assist, and you should use the drafting assistance when you're prepping for a moot that is just orally, because either way, you need to have a structured argument. So moot court has to be approached like a whole new language that you have to learn. And we can actually end my presentation right here with my last sentence on this slide. You have to teach your brain a new language, and you do that by reading case law. Make time to read a Concord case from start to finish. You'll see there's a certain structure, there's a certain way. There are places where you put the facts, there are places where you put the case law and the legislation. there's a certain way of speaking, there's certain words and legalese and lingo that you need to learn. And then also there are moot court etiquette that I think Herman will probably talk about that a little bit. But when you start taking part in moot court, you'll get the gist of that. I also just want to add with what Chris said about when you start clerking or doing your articles, you will be sent to court, and it is something you will eventually have to do unless you end up doing only like a conveyancing in a firm. So it's not something you should be scared of, because it's not going to put off the inevitable. And this is a good way to get confidence to eventually know you'll one day have to walk into a courtroom. And even though when you clerk, you're not going to do appearances in court that are as exciting or legally technical as moot court, but it helps you to structure your thoughts and to see the bigger picture in between the facts and the law and the documents and the file, and you'll have to index the file and you'll start with really small applications in court that seems like it's so easy. Why do you need a degree for this? But it's because you need to approach any type of case in a logical fashion, and moot court really helps with that mindset. So what comes first? So you receive a set of facts, and this will be your baby. You really need to know that set of facts really, really well. And the first step is to dig in. You need to read through that. Sorry? Okay. You need to read through your set of facts quite a couple of times with your teammates and your coach. And now I'm going to give you a breakdown of what I would do if I were you after I've received the So I'm so sorry, someone's microphone is on. If you can just check if that's perhaps you. Okay. So here's a silly set of facts. I'm not going to read everything now because I have 10 minutes left. But let's say you receive a set of facts from moot court, and the applicant is a grandmother of a minor child, and she's applying to the court for the child to live with her, to have full-time residence and care and contact of the child because the parents are negligent in the opinion of the grandmother. Let's say these parents are really pressuring this child. The child is busy with extra classes and extracurriculars and what all day long. She doesn't have a social life. So let's say this is now our set of facts that you're getting. So here I have a little table that this is how I would suggest you approach set of facts, but you'll get your own way of doing it. I just really like a table that likes wat dinge mooi uiteensit. So firstly, you'll read through the facts. Then I give you a tip there, like don't make any notes. You really need to read the facts and you need to focus. And then when you read it through the second time, you can determine what are the issues. So sometimes a set of facts clearly state at the end that these are the issues you have to argue in court. Other times it doesn't. So then you have to start looking for like what are the points that the applicant and the respondent agree over, what is in contention, because it would be very incorrect to go and argue about something that's not an issue. Okay. Then what I would do is I would make a list of the specific legislation or international treaties that's specifically mentioned in that fact, because it's like a clue they give you. That's a road map, a road sign. It's a green light from the people that drafted the set of facts. So you definitely cannot ever forget to check that out. Then if I were you, I would draw a table in which you summarize the different party arguments. Now, this is now before you've done any research, né? So this is one-liners that you're going to give yourself, just so you can start seeing a bigger picture. I'll show you how I would do it in a minute when I get to the next slide. Then identify further legislation that's applicable, and then open a document or just have somewhere you jot down everything, all your thoughts. You need to become a creature of using your pen or your pencil at all times when you start practicing. If you're either going to go into practice or consultation type of work, either or, you need to get in the habit of writing down everything, because the shortest pencil is longer than the longest memory. That's advice I received on my first day at Warren van Rensburg Attorneys, which is where I'm clicking. So here I'm just going back to step 4, where I told you you could just make a little table of the issues in dispute and what each party is saying. For example, you'll always start by discussing jurisdiction and locus standi. You can't just run to any court with any matter. You need to make sure that your client is going to a court that has jurisdiction. So you try to kind of figure out, is the applicant and the respondent saying yes, or are they saying no? And then you'll see here, I just used the set of facts that I very quickly spewed at you to, for example, the set of facts could be about the best interest of the child, and then you just say, you know, what is the applicant's current idea? What is the best interest of her grandchild? And what is the respondent saying about that? Just so you can, you really need to have a structured way of thinking about it, because otherwise you're going to have jumbled arguments and you're wasting the court's time. Okay, now that you've done the set of facts part, and it really will pay off to spend a lot of time with the set of facts before you do your research. It will pay off. Then you can start. So firstly, there's no time today for me to really show you how to do research. I'm not going to do that. There are many places on campus that you can get assistance. The librarians at the library can help you. Legal Behemoth has workshops usually. You can ask your LP or C lecturer, if I remember correctly. But to start research, textbooks are always a good place to start. I know the library is probably closed right now, but if you have your textbooks, you make sure it's an up-to-date textbook, and it could really help if it's an area of the law you know nothing about. Then, of course, check out the Constitution, legislation, case law, and good old Google. With Google, what I mean with Google is if you're participating in an international moot court, it's a good idea to look online, for example, of previous heads of arguments. Usually they put the winning heads or the winning memorial on a website somewhere, and that can be a great tool, not to plagiarize, but just to assist. So here is the actual databases where you'll search for case law, and I suggest not just for moot court purposes, but for study purposes and then eventually work purposes, to really learn to find your way around these sites. You don't necessarily know if your employer is going to have access to it, but if you're first year, that means you have 4 years or 3 years left. If you want to do postgrad, you have 5 or 6 years left. Do yourself a favor and get acquainted with LexisNexis and JUTA especially. So where to start with research? There's no set way to do this. You'll get your way and you'll get your process of doing it. So today I'll just sort of assist you with how I would do it. But this is a difficult part. I can explain to you and I can show you how I do it, but you need to go find your own way. You need to go your own way and spend some time with figuring out a process that helps you best. So a good way to start is with keywords, and the more you read case law and the more you do moot court, you'll figure out and identify keywords a bit easier. But let's do best interest of the child. With the COFC moot, that's usually a big area that when you have to do with kids, you always touch on best interest of the child. So while you're doing research, with every source you read, always consider it from the viewpoint of both parties and make a note of it. Have a file on your computer or a notepad there. If you read a case and something interesting pops out, be like, why would the applicant use this? Why would the respondent use this? Why wouldn't they use this? And yeah, if you think you'll use it, save it or make a note of it. So let's say you have now a source that works for you. You have to apply it to the facts. So this is really important, and this is the difficult part. This is the first moot court I took part in, was just an internal moot that Legal Behemoth arranged, and I handed in heads that had so much case law, but I never really said why I was using it. And yeah, it must be really irritating if you're reading a heads and the the lawyer is just like summarizing case law, and then you're like, okay, so what? So what? That's a really relevant question. They could have asked me, but they were quite nice about it. So let's say you find a case, and this case discusses the applicable legal principle that you are using to argue, such as the best interest of the child. You must clearly apply it to the facts. You must be able to explain why it's relevant. Is it binding on this court? Are you using a Canadian case for the Free State High Court? And then is it still applicable? So be wary of just repeating what the court said in the judgment. Be wary of just repeating an act or a statute. And then always consider how the opposite party might interpret it. So let's say I'm using M versus S, which is a case. You'll see I highlighted a little bit there. A truly principled child-centered approach requires a close and individualized examination of the precise real-life situation of the particular child involved. How would you apply it to this set of facts? You'll say to the court that the grandmother, or yeah, for both parties you'll be able to use it. Like, for every child, it might not be good to be put under this amount of pressure. But our child is not like every other child. She can handle all the pressure. And the court said in M versus S, we must take a child-centered approach when we are making decisions about children. But here you'll see I made a little another table, because I like my tables, to give you a really basic view of how to structure an argument. So you'll see your whole heads of argument will look like the left side. You'll start with an intro. Oh, I see my time is almost up. I'm going to beg for two more minutes. I beg the indulgence of the court. So you'll start with an introduction, then mind map. You're going to tell the court, I'm going to talk about issue 1 and 2. Then my learned colleague is going to take over, discuss issue 3 and costs and prayers. But the most important part for now is the column right next to it, which is the basic structure of an argument. And we call this a syllogism. So you start with the major premise. And the classic example that's used is all men are mortal. Then you add your minor premise. Socrates is a man. And then the conclusion, therefore Socrates is mortal. And I always steal this idea from Andries Vermeulen, he was also a chairperson, of Legal Behemoth years ago. So here I structured an argument that's not based on our set of facts that I've discussed thus far. Even though I'm clerking in the litigation department, I'm helping some clients with their Protection of Personal Information Act compliance. So I'm going to use an example like that. So let's see. When we start with a major premise, you'll see the second line there. The classic example was now all men are mortal. Let's use an actual act example. So section 55.2 of POPIA requires that all public and private bodies that are not exempt from POPIA must register their information officer. So that's the major premise. Now you have to consider, is this applicable to my case or my facts? So let's say you're representing a law firm. You're like, yes, POPIA applies to ABC attorneys. It's a private body. They are not exempt. That's your minor premise. Your major premise plus your minor premise leads you to your conclusion, which is, therefore, ABC attorneys will have to register their information officer. Here's another example. I'm not going to discuss this one. I'll send the slides to, or I already have sent the slides to Kamagelo, and then you can just send it to you. Where I also used a section from a paragraph from a case. Then I said, this is what the facts say, and then your conclusion. Great. I'm not going to go through everything else. I'm going to conclude now, so you'll just check out my PowerPoint, but you need to speak much slower than I'm speaking right now. You need to be ready to learn, like Christopher said, feedback is really difficult. It's something you need to learn to deal with. Otherwise, you're going to be a very irritating colleague one day. And then please go check out these 3 videos that I sent the links of. I highly suggest you go look at that just to get some inspiration. And then just back to my first slide, the secret is really to make time to read. Thank you so much. If you have any questions, you're welcome to put on your mic, or do you want to wait till afterwards, Kamagelo? But that's my story.
Thank you so much, Carita. Thank you for the practical examples that you gave us. Right, I'm using a different platform now because the phone that I was using is giving me problems. I don't know if I'm still audible.
Yes, you are.
Okay, thank you so much for the practical examples that you gave us. I guess the students, if you've got any questions, please type the questions in the chat box, and Carita and Herman and all the speakers will attend to the questions later. Right now, I want to introduce the speaker, Mr. Herman Durant. He will be speaking on oral advocacy and the skills that one needs to possess in order to successfully partake in the moot court. Over to you, Mr. Herman. You said you do have slides. Please upload your slides and you can commence with your presentation. I love the background.
Good afternoon, everyone, and good afternoon, Kamagelo. Thank you for the invite. I did prepare slides, however, in a last-minute decision, I've decided not to share them, specifically because of the fact that we're going to be discussing oral advocacy and how I want you to address the court, as well as, which is a very big part of it, body language. And I want you to be able to observe my body language instead of being distracted by the slides that I've prepared. So I can have a discussion with Kamagelo maybe about making some notes available to everyone that would like to have access to them. However, I'm not going to sit and do a slide presentation. I'd like you instead to pay attention to what I'm saying and how I'm saying it, rather than looking at a set of slides. I think especially to those of you that are taking part the first time, I cannot stress enough the importance of being present while you're doing your presentation. And at the end of the day, if you are constantly distracted by something, not only will the judges realize it, your co-counsel will realize it, the opposing team will realize it, and at the end of the day, it's not going to be an enjoyable experience for you. So just in terms of that, that's my particular preference in terms of not making slides available. And that's why I won't be sharing slides, though I would be happy to give a few pointers by way of email to Kamagelo should anyone want just access to that. What I just want to start with today is just quickly touching on a few aspects. The first aspect that I would like to touch on is oral advocacy, which Kamagelo has already indicated that I will be addressing. And in particular with oral advocacy, what I just want to discuss with you first is everyone thinks that in order to be able to argue in court, you need to be the best speaker. You need to be the one that speaks the most beautiful English, and your pronunciation is perfect, and everything about the way that you talk is so great to listen to. The problem that many of those students face that are indeed so well spoken and so confident, and you can just listen to them for hours with what they're saying, you have to make sure that when you are sharing something, it's actually worth sharing. And a lot of students lose that point. So they focus so much on how they speak that the content that we actually want to hear, the question that I've just asked you, you're focusing so much on speaking beautifully, on speaking the best possible English, that I'm not understanding what you're telling me. You can speak the most beautiful English with the most complicated words that anyone in the world has ever heard, and it's not going to have the impact that you want if you're not speaking sense. So that's the thing that I want to bring to your attention first. You need to have confidence, but please make sure that your confidence is not simply confidence in speaking, but confidence in what you know. And that is where Carita's presentation comes in. The building block and the foundation of any legal argument, of any moot court that you will ever take part in, will always be the research that you did beforehand. You can be the single best speaker in the world. If you do not have content worth speaking, why are you doing moot court? You can rather go and do some kind of, say, for example, a speech somewhere which will impress people, public speaking, if that's what your goal is. But the goal with mooting is not simply to speak well. It is to speak well and speak sense at the same time. So just in terms of oral advocacy, that's what my personal preference is. That's what I believe in doing when you're talking about oral advocacy, that although confidence is important, and of course, as much as you can improve yourself and improve your own verbal skills, please do so. It does create a brilliant, good first impression. But if I don't understand what you're saying, or if I can clearly see you speak very well, but you haven't done the research and the legwork to get where you need to be, you are not going to impress me. And then, quite frankly, I'm asking myself, why are you in a moot court instead of simply a debating competition? A moot court is not simply debate. A moot court is focused on fact-based arguments that you need to make based on the research that you've conducted. So that's just in terms of oral advocacy. Your oral advocacy must not only be confident, but it also needs to clearly convey that you've done the legwork and you've done the research in order to be able to address the court. One very important thing that I just want to mention to you, try to be consistent when you're addressing the court. If I'm speaking to you the way that I have been now, and the next moment I'm speaking so softly that you can barely hear what I'm saying, and my shoulders are dropped and suddenly my body, at the end of the day, you will never convey to the court that you're consistent. So please also just, and this is where the danger comes in with moot court and with the way that you address the court, don't do everything the exact same way constantly. Because otherwise, if you keep on speaking to me with the same tone of voice and you just keep on going without any kind of, just going up and down with your volume or, having some kind of engagement, at the end of the day, you're going to make people fall asleep. They're not going to be interested in listening to you. So as much as your content is important, the way that you address your content is also important. So it's about finding a balance that works between making sure that, first of all, your foundation is well laid, and second of all, that you are then clear and consistent when addressing the court. One of the things that Carita has already touched on in terms of, moot court and what you should do and what you shouldn't do, I cannot stress enough, ladies and gentlemen, how important it is that you ensure that you stick to your time limits. I'm not talking about the 30 minutes or 30 seconds or a minute that you might go over time, or maybe if a judge still has a question afterwards, that's no problem. You can handle that. And it does happen sometimes that you can overshoot your targets because judges ask too many questions. That's normally not an issue. They will offer you an opportunity to just finish in most circumstances. But if you on your own have been uninterrupted for the most part of your argument, and let's say you were afforded 10 minutes to speak and you've gone over that, why did you go over that? You were afforded the 10 minutes. Normally, that 10 minutes would include questions. So if your speech exceeds 10 minutes without any questions being asked, you are not managing your time appropriately. Make sure that time management in terms of oral advocacy is important, because it also conveys to the judges that, listen, I know what I'm doing, I know what my time limits are, and I have prepared accordingly. I can address my entire argument in 8 minutes if I have to, or quite frankly, in 1 minute if that's what's required of me. Because it happened to me personally in one moot court where I had so many questions throughout the entire moot competition that I could not at all get to my argument. I started with my opening line and the first question came. I finished addressing the first question and the second question came. And so we ended up having a conversation. And at the end of it, the judges asked me, listen, just in 2 minutes time, summarize your argument for us. So my entire speech of 4 pages that I prepared, thrown out the window, and they asked me to summarize my entire argument in 2 minutes. That can happen. Make sure that you manage your time so that if you get, for example, into a situation where I have 2 minutes, you are still able to, within that 2 minute time frame, briefly address the judges in terms of what the core of your argument is. And then something that I want to address to you that I've seen quite often many students struggle with. They see, for example, that for me, I use my hands when I'm speaking and I do a bit of expression and I move my hands around a bit, not too much. but just a little bit. And I will sometimes bring my hands up like this and I'll take my glasses off because it buys me a moment worth of time while I'm thinking. Someone else will sit there and they will not move at all. And this is the way that they will address the court for the remainder of their entire speech and for any question that is asked of them. Please don't think that there's only one way of having your body language. Being consistent and being confident, that's important, but you need to make sure that you are comfortable with the way that you're addressing the court. So there are some basic pointers that I'm going to be discussing with you guys, but the most important thing that you have to remember when you're addressing the court is, what is your style? What makes you comfortable and what gives you the confidence in order to be able to address the court the way that you're supposed to? So that's just in terms of oral advocacy, a brief introduction, just a few brief pointers on what I think is absolutely important with how you handle yourself and how you speak in a court. What I want to address next is just some basic etiquette. And quite frankly, I know Carita will probably have seen the directive that went out as well. I believe it was the end of last week. The Magistrates Court in Bloemfontein actually sent out a directive asking people, please stick to court etiquette. There are certain rules, there are certain directives, and there are certain ways that we do things, and people haven't been sticking to that. And that's a clear example that it happens even in practice, but the magistrates, the judges will ask you to keep to etiquette. And if you know what you're doing, you'll immediately create a good impression with your court etiquette. So just some basic things. The first thing is when you stand, and normally when you're in person or when you sit down, for example, like we are with this Moot at the moment, just sit with decent posture. If I sit here and I'm down here in my chair, and when I'm sitting here, I'm just chilling and I'm talking to the judges and, let me just check my watch first. At the end of the day, what's going to happen is the judges are not going to be impressed because your body language indicates to them that you are uninterested in what is busy happening at the moment. It's an extremely disrespectful way of appearing in the courtroom. So I'm not saying you all have to stand with straight backs, and use a broomstick to keep your back straight, all those things that people say. Just stand with decent posture, sit up straight, and look to where you're supposed to be looking. If, for example, I'm sitting and I'm giving this presentation, I'm busy speaking, and all of a sudden, I just start staring at the door, waiting for someone to pass by in the corridor, you're showing disrespect towards the judges. So especially when we are doing virtual matters, please make sure that you're in a space that allows for that. Because if you don't, if you sit, for example, in a public area and you are constantly distracted, it will be noticed. I know that that's an exceptionally difficult thing because not everyone has access to a space that is necessarily conducive to such peaceful, conversation and having that opportunity. But it does remain exceptionally important to try and be in a space where you're uninterrupted, especially while you are doing the Moot virtually, which I assume at the moment this Moot will be, all things considered, and the way that things are going in our country at the moment with level 4 of the lockdown. Then the next very important thing is, ladies and gentlemen, please stick to the correct forms of address in court. If, for example, you are in the High Court, for argument's sake, and you start referring to the judge as Your Honor, the judge will not be happy, and they will point it out to you, and they will ask you, are you South African? Because there is no Your Honor in South Africa. In South Africa, in the High Court, we refer to my lord if the judge is male, or my lady if the judge is female. And then if you refer to a bench, which is what will happen in most moot courts as well, where, for example, there are two men, then you refer to my lords. Or if there is a man and a woman, you refer to my lord, my lady, when you address the court. It's something small, but it's exceptionally important because it also shows the court that you are actually comfortable in addressing the court, which has an enormous impact on how they view you, just in terms of knowing you are actually doing what you're supposed to be doing. And you know that the appropriate form of address is the following, and we are, comfortable with the way that you're supposed to be addressing people. And it's just also as important when you address your co-counsel or the opposing counsel that you also use the correct forms of address. So, for example, when you say my learned colleague, that would normally refer to the opposing counsel. And then if you're, for example, referring to your co-counsel, then you can say to the court, my lord, my lady, that particular aspect that you just questioned me on will be addressed by my co-counsel in his submissions or in her submissions. If the court pleases, I can give a brief exposition of that, but however, I would refer that matter to my co-counsel to address or to my colleague to address. If you refer to the fact that, say, for example, the opposing counsel made a statement during their arguments that you don't agree with, then you will say, my lord, my lady, contrary to what my learned colleague has submitted to the court in their arguments, I will argue the following, and then you address that. So just briefly in terms of what I think normally works well there. Then also something that's very important, please dress neatly. So what, for example, happens is someone will show up and they have a tie, they have a shirt, and they have a jacket, and everything is fine, but their tie isn't properly tied, or their tie sits like this for the entire competition. And, you know, the only thing that the judge is looking at is your tie, wondering what happened. Does he not know what his tie looks like? It is quite important. We have a very formal, in terms of, you know, dress code and as well the etiquette that we have in courts. In South Africa, we have a very formal way that we deal with things. It's not necessarily always, you know, only black and white and as strict as people can make it out to be, but being neat is still an exceptionally important part of any court that you want to address, you know, in a South African context. Then I just briefly want to move over to some do's and don'ts. You will prepare an argument beforehand, especially if you're the applicant or, you know, if it's an appeal case, the appellant. You will prepare an argument, and normally it more or less goes according to how you structured your argument. You will start by addressing certain aspects of the case, and then you'll say, okay, we have 3 points that we're going to address. I will be addressing the procedural point first, and then my colleague will be addressing or my co-counsel will address the 2 substantive points subsequent to that. That's great, that's fine, but just remember, you won't always be able to stick to that. So yeah, just in terms of that, again, back to the oral advocacy, you normally have a structured argument, but that is based on the research that you did. And quite frankly, as far as I'm concerned, that should form part of your research element is how am I best going to convince the court of my case? So yeah, just with that, keep that in mind. And very importantly, please never read your argument. I see this a lot in students, so they've done so much effort in preparing the perfect speech that they'll sit there and they will keep their papers with them, and as they're discussing, they will read and say, okay, it's very important to do research, you know, you've got to have talking points prepared, and at the end of the day, you're not addressing the court. If that's what I wanted, I could have taken your heads and I could have read your heads of argument, and I wouldn't have asked you to address the court. So please make sure that you don't read. There's nothing wrong with, for a moment, looking down to your points and seeing where you are, which is normally why personally also I prefer not to write out a full speech. I have certain points that I need to address, and again, this is a stylistic just preference of mine. So I don't always have a full speech written. I will write down particular points that I want to address, and then based on those particular points, I will address that. Some other people, some of my colleagues that have done brilliantly in moots that I've taken part in, write out a full speech, but they still stay adaptable from that speech. So just keep that in mind. Don't read your speech. You can prepare a full speech right from your introduction down to the end, saying literally every single word that you plan on saying. But don't get caught up in that and start reading your argument. The judges can read, and they can read your heads of argument, and they will end up telling you that they really don't need your assistance to read. So please make sure that you keep that in mind. You want to address the court. You're not here to read to the court. Another thing that's very important is please don't fidget. It is distracting. So for example, if while I'm addressing you, I constantly sit and I'm turning my pen for the entire speech that I'm doing, and you know, I can be telling you all of the brilliant things that you want to be hearing, and I'm such a wonderful speaker and my research has been done. But at the end of the day, you're going to be wondering why I'm sitting playing with my pen. Am I not confident in my arguments? Am I not comfortable looking at the judges? Do I not realize that you can see me? So just try to limit your fidgeting as much as possible. I had a colleague that when she would address the court, Sorry, is there someone that had a question?
No, there's not.
If you can all just maybe make sure that your what you call it, your microphones are off, I think that would be great. It seems like someone is having a conversation in the background. Thanks, guys. So yeah, please just make sure that you don't fidget unnecessarily. Obviously, we move around and you have to, address things, and you're welcome to pick up your papers and you move over to your next page. There's not a problem with that. But if you're constantly sitting and fidgeting with your papers and doing this the whole time, and then you're moving this and you move it back and you're sitting like this, it makes you look less confident. And it also distracts the judges from actually listening to what you're busy saying. Another very important thing, and this happened actually during a moot that I was a judge at, and immediately, I was so kind of caught off guard by this that I ended up not really listening to the rest of this person's argument because he wasn't doing what he was supposed to be doing. Please don't constantly, while your co-counsel is speaking, try to listen. Listen, I just need you to also do this. You will get your speaking turn, or you've had your speaking turn. If there's something that is critical for you to address, silently pass your partner a note and say, please leave this to me, I will address that in the next one. But if you constantly interrupt your own co-counsel, I, as a judge, will never see you believing what your own counsel says. So if you don't even believe what your partner is saying, why on earth should I believe it? If you don't have confidence in what your co-counsel is saying, why should I listen to him? It's a very, very simple thing, but it comes across as extremely disrespectful towards your own co-counsel, and also very clearly indicates to the court that you don't have confidence in what this idiot next to you is saying. So be careful of that. It's really a simple mistake to make because you get so excited in that moment and you just want to share with the court and you want to make sure that you get this right because you have the perfect answer. But if you keep on interrupting your co-counsel, you will create the impression with the court that you don't trust your co-counsel. And that's never a thing that you want to do. Just one last don't that I want to address. Please don't be overly dramatic. I know that as Moot students, we get passionate and we want to get up and say this, but if you start jumping around and you get so passionate that you can't sit still, and now I'm moving like this and I'm jumping like this, at the end of the day, it's the same thing. It's distracting. As much as we should always be confident and, be passionate in the correct moment, it has its moment. And it should stick to that. If you are constantly doing that for the entire moot, I'm going to be wondering, but are you trying to distract me with your behavior so that I don't actually listen to what you're saying? And then I'm going to get concerned about your confidence because then you're trying too hard, which also happens sometimes. So just keep that in mind. Then a very, very, very important do in terms of body language and in terms of just handling moot court, please listen. You'll sometimes get students that give you the most beautiful answer to a question, but they haven't answered the question. They've answered a question that they thought you were asking because halfway through what you were asking them, they start speaking and they are now fully convinced that they know what you want to say before you've even finished your sentence. Be careful of that. Listen until the judge is done. Give that extra second or two. And even when your opposing counsel is speaking as well, give that moment. Listen to them. Make sure that it also looks to the judges that you are actually listening and paying attention, because it gives confidence. And when you disagree with your opposing counsel, this is again a personal preference, I would sometimes look at the opposing counsel and then just look at the judges, and they can immediately see that I don't agree with what he's saying. I don't have to make movements. I don't have to be distracting. I can just look at him and look at the judges, and they know, I think this guy doesn't know what he's talking about. So again, listen and make sure that everyone knows you're listening. It can also be, quite frankly, a bit of an intimidation tactic that will throw your opponents off balance at times, particularly during moot competitions, not so much in practice. That will just, again, make sure that you keep your opponent off balance if it does make a difference at the end of the day. And then the last thing that I'm just going to touch on for 2 minutes, I see my time is nearly done, answering questions. And it comes right down to just one statement. I'll address a few things, but the most single important thing that you can ever do, please answer the question. If someone asks you, Mr. Durant, do you think that, or let's change that. Let's say, Mr. Durant, do you think that the Constitution of South Africa is applicable to this case or has an impact on this case? And then I start telling you about, the Children's Act says this and the Constitution says the following. But I never tell you, yes, my lord, I believe and I submit that in this case, the Constitution is in fact applicable because the rights of children are affected in this case. And quite frankly, my lord, the Constitution of the Republic of South Africa is our most enshrined and most important document. If that's how you want to address it, then you do it that way. But make sure that you actually answer the question. So if someone asks you a yes-no question, answer it and then give the authority. Don't give so much authority and context that you never end up answering the question. Because now you're telling me about the Constitution and what a wonderful document is, and that it's the supreme law of the Republic, but you've never told me yes or no, it is actually applicable. Answer the question. Please don't miss that. Again, when you're answering a question, try to look at the judge and look at the judge when the judge is asking the question. And if, for example, there's a speaker, someone else speaking that is asking a question, during your co-counsel's address as well, this is exceptionally important. Please listen to the questions asked to your co-counsel. Because if he doesn't have the ability to answer them, then you can answer in your address. It's actually allowed for you to address a question that your co-counsel couldn't answer. Because sometimes you will just, by accident, happen to have read a case that answers the question. So make sure that you listen even to the questions that are asked to your co-counsel as well. And then one very important thing, you will see that some judges will ask you a lot of questions. Use those questions to come back to your submission. So, for example, what some judges will do, they'll ask you a question that's already addressed later in your argument. And then you will say, my lord, in fact, this point I was trying to address, or I was planning on addressing later. However, if it pleases the court, I will address that point now and then continue with the rest of my argument. And then you address that particular point in your argument right there and then. Don't tell the judge, listen, just hold on, I'll get to it. I'm getting there, just a moment, like it's later in my speech. The judges won't appreciate that. They'll think that you are very arrogant and rude. So please just, in terms of that, say, my lord, I was planning on addressing this at a later stage. However, in order to answer the court's question, I will address it at this point. So just keep that in mind. And then the very last thing in terms of answering questions that I just want to say to you is, please use authority, but use it concisely. If, for example, the argument is based on, let's say, the right to life, and you addressing something about the death penalty in South Africa, then say, my lord, in terms of the case of the state versus Makwanyane, the following principles are applicable, and therefore I would submit the following. Don't go all the way, behind the mountain and then go and get the cows there, and then it's really not necessary. You have a limited amount of time, normally 10 minutes, sometimes even less. Keep your arguments concise and use authority, but make sure that you use it concisely and effectively. If you end up talking about 50 cases during your arguments, at the end of the day, the judges won't remember all of them. But just make sure that you please use the ones that you use effectively. There's no point in telling me 50 cases names, and I have no idea why any of them are applicable. So address me on the cases, and then we'll make that happen. Then I see there's a question. There's a question about how we address judges from courts other than the high courts. So, for example, in South Africa, in the magistrate and regional court, we refer to the presiding officer as your worship. That is regardless of sex. We don't make a differentiation there. We just say your worship. Then in the high courts at the moment, we say my lord, my lady. In the Supreme Court of Appeal, it used to be my lord, my lady, but there's a directive, I think it was in 2014, where they said that we are now phasing out my lord, my lady in the Supreme Court of Appeal. We now refer to the presiding officers as justice. So, in the Supreme Court of Appeal, there is normally 5 justices sitting and hearing the case. And then obviously in the Constitutional Court, it is also justice, except when you're addressing either the Chief Justice or the Deputy Chief Justice, at which point you'll use those forms of address. So your lower courts are your worship, high courts, my lord, my lady, Supreme Court of Appeal is justice, and the Constitutional Court as well is justice or chief justice or deputy chief justice. Then I see there's a second question that you can ask, whether you're allowed to ask them to repeat the question. If you think that it is going to be enable you to answer the question, then yes. sometimes it'll happen that the way that the judge has asked the question is difficult for you to understand. So then you can just perhaps say, my lord, if I understand your question correctly, you've asked me the following. And just briefly say to them, is this what you've actually asked me? Otherwise, I'm going to be wasting your time. So you're allowed to ask them to repeat a question, or you can just say the question back to them in a way that you understand and ask them whether this is actually what they wanted you to say and what they want you to address. So I know this is an enormous amount of content that I've given you in a very short period of time. And there's actually quite a lot still that I would like to say to you in terms of how you should structure your argument and how you should start from a logical point and continue to a certain point. Unfortunately, our time has run out. I see that I'm now exactly at 30 minutes, which is what Kamukelo asked me to stick to. So I'm going to conclude my submission there. But just on one last point, if anyone feels the need to make contact with someone, please make contact with candidate attorneys and attorneys in practice. They will assist you if they are able to do so. I've had some students that are first or second or third years that I've known over the years that have contacted me about certain things, and I always assist if I'm able. So make sure that you build those relationships even now when you're doing Moot. And just make sure that you make yourself available and get to know as many people as you can, because law is not only networking, it is networking, networking, and networking to get things done in practice. So the best of luck to all of you. I sincerely hope that I'll see you all again, and I definitely look forward to hearing when the Moot is actually taking place, so that I might pop in and just have a look at what you guys are doing. Kamukeli, thank you for your time, and I'm very happy to see how many people have attended today. All the best, guys. Kamukelu, I think your mic is still muted, so you might just want to turn on your mic.
I have been speaking this whole time. Honoring you, thanking you so much for being here, giving you all the credit. I started by saying, if it pleases the court, your honor, because I remember you were a judge the first time I took part in the junior internal Moot court competitions. But we are very grateful, Harriman. We are very grateful for your presence, and I think the students have had a mouthful. Guys, I hope you are taking notes, especially the junior students, because we are going to see Herman a lot. You guys are going to see Herman a lot, and this is him at his friendliest. That I know for sure. Musandiwa, can you please mute yourself? You're distracting us. Thank you very much. Now I would love to move to dialogue chapter. If you've got any questions, please put the questions in the chat box. If we cannot respond to the questions, we will email the questions or send the questions to the speakers, and we will respond back to the emails. And if anyone is concerned about the answer that has been given to a particular question, you can still say, "Come, I'm concerned with the question that was asked by who and who. Can you please send me the response that was given by the speakers?" Now we're moving to dialogue chapter. Dialogue chapter is our senior Moot, meaning that he is my superior. So he is my boss. So I need to behave. Do I look proper? Okay, for my boss. Thank you so much. So dialogue chapter, we'll be speaking about the pros and cons of Moot court, what he has noted, because the senior students have already participated in a couple of Moot courts. So he will note what he will speak to us about what he has noted about what are the mistakes that have been occurring and things like that. Mr. Chapter, are you okay to speak? Okay, Mr. Shanti, you may speak. All right, not a problem. Then we will jump to Danielle Durand. We were doing Herman Durand, now it's Danielle Durand. I didn't, so yeah, it's the Durand family today. Jokes, I don't think they're even related. Danielle Durand also participated in the 2020 2020 or 2019. Hello, we are old. 2019 Kofsi Moot that was held at the Supreme Court of Appeal. She will also be sharing her experience of moot court. Danielle, are you okay to speak now? Just indicate.
Yes, Kamu, I'm perfect. I can speak now.
Oh, I love the smile. All right, Danielle, you may start speaking. Thank you so much for honoring us.
Thank you. Firstly, Herman and I were not related. So let's just clarify that. And then, as Kamu stated, I'm going to speak about my moot court experience, and I was in the 2019 moot court. So I started participating in moot court in 2019, and I started by participating in the internal moot court hosted by legal Behemoth. And at that moment, I did not know how to draft my arguments or how to speak. And expecting nothing thereafter, I got an invitation to participate in the annual Kofsi Moot. And within a very short amount of time, I had to learn how to do research, how to draft my arguments, how to present them, mostly how to speak, because I could not speak at that time. And honestly, Moot really, really changed my life, because I wasn't motivated to get this degree in my first year or my second year until I started participating in moot court. And moot court really, really gave me all these nicks and tricks, especially my coaches, Herman, Carita, and Carmen. They really gave me all these nicks and tricks that I still use up until today. And moot court really is a very, very fun experience, because you can make all these lifelong friends and you're meeting so many different people. And that is really, really great. And one thing that I always turn back to is that celebration evening where I thought to myself, I can't believe that I'm there, that I participated in an external moot. It really, really changed my life. And I will most definitely do moot court again, and I would really recommend to anybody to do that. But I also have to say, although it is very, very fun, you have to know that it is a lot of effort. It takes a lot of effort, and it's long preparation and research hours and a lot of late nights. But in the long run, it really, really teaches you to take skills that you did not previously possess and apply them to your daily life at this stage. So really, really would recommend moot court. And I know a lot of you have the question where you are wondering, what is the difference between an external and an internal moot court? And externally, I want to say that the judges are really highly skilled persons in the professions. They have years of experience and they have a very vast knowledge of the law. Whereas in my experience, the judges were the legal Behemoth EC. So I have to say in that regard, it was a bit nerve-wracking participating in the external moot court, but it really was worth it. So I was privileged enough to learn a lot from all my coaches. You know, that is something that I really want to advise you on. If you're privileged enough to have coaches, listen to them, because they are passing on the knowledge that they had previously to you. And those are knowledge that you can use and pass on to other people, for example. So really, really listen to your coaches and take their advice and apply it to your life. So yeah, and that's something that I want to end up with. Just be open to learning, because if I wasn't open to learning, I wouldn't be where I am today. You know, I wouldn't have been able to participate in the Kofsi Moot. So yeah, just enjoy the experience and learn as much as you can and just enjoy it. That's all advice I can give you. And then on to you, Kamu.
Thank you so much, Danielle. I am grateful that out of all the speakers that we have had today, you're the only speaker that managed to keep up to the time. I'm very grateful. And you also took note that when I I released my face that, oh my goodness, my time is over. Let me give the platform to the boss. Without any further ado, we're very grateful, and I love the smile. I love the smile. Keep the energy like that. Taelo is still having connectivity issues. We will move before we give his apologies. Can we kindly move to Tobeka Dlamini? Tobeka Dlamini is the subcom member, meaning that finally I get to be a boss. She is the junior Moot subcom member. She participated in the 2020 Kopsi Moot. So she is going to tell us about her experiences of mooting during the pandemic, because we've never mooted during the pandemic. We don't know what are the pros and cons of, especially for a junior student that started mooting in the during the pandemic. So Tobeka, are you okay to speak?
I am okay. Can you hear me?
Yes, I can hear you.
I'm trying to open up my camera, but it's doing the thing.
Okay, I think if it is...
So let me just do because I have 7 minutes. Literally.
Just commence with the speech.
Okay, cool. So, hi everybody. My name is Tobeka Dlamini, like Amkhalo said, but everyone calls me Noma. That's why my name is Noma there on the screen. I am a second-year student, law student, as I have already been introduced. So, when Kamukhalo asked me to speak about my mooting experience, I must say that it was a bit of a hassle for me, considering the fact that I never went to, well, we didn't go through to the final round, right, whereby we orally represent our cases. But while I was busy drafting down this speech, I actually realized that there's a lot of things that I learned throughout this whole experience. Bear in mind that I have been involved in 2 moot courts so far in the university space. The first one was the Nelson Mandela World Human Rights Moot, and the second one was the Kopsi Moot, right? So there's a couple of things that I have learned through both of those experiences, and I feel like I hope that everybody finds it very beneficial today. Based on what I'm going to say, but this is what went down, right? So on the 29th of June, myself and about 503 UFS students received an email notification from the legal behemoth informing us about this Nelson Mandela World Human Rights Moot. And I must say, the reason why I'm emphasizing the fact that there were 503 of us who received that email, this is the reason why, that everything that we have received today, every single advice that we got, this whole training that we got is so irrelevant if you're not going to actually go into these moot courts, right? When I looked at that number and all those email addresses that were showing up on my screen, it was very intimidating to me. Firstly, because the Nelson Mandela Human Rights Moot was an moot court competition that was not specific for a certain field of study or year of study. So it wasn't for first years or second years. It was just like law students in general. So for me at that time, I'm thinking, oh my goodness, there's probably going to be third year students and they have experience and I'm just wasting my time. Why am I even doing this? So all in all, I had 2 choices, one of 2 choices to make. It's either I shy away and tell myself that, you know what, I'm not going to do this. These people are more experienced than I am. Or I was actually going to wing it and then hope for the best. So what did I do? I winged it and I hoped for the best. Started drafting down my heads of argument. I had no idea what heads of arguments were at that point. So I headed over to the Legal Behemoth YouTube channel. They have this video whereby they're helping you draft heads of argument. I followed every single step there. With the legal research, it was a problem for me because firstly, I'm first year. Secondly, I've never had an experience of mooting in the university space. So I don't know what are the requirements, where to go and everything like that. So at least I managed to ask people in other years of study that, can you please help me out with this thing? I'm struggling, right? So eventually I submit my heads of argument to Legal Behemoth, and only on the 27th of July, 2020, I received my confirmation stating that I have made it onto the university team. Yet again, I was very much intimidated, considering the fact that, again, I have this feeling that what if I was just the people who were allocated or who were selected to be part of this of the university team are just as the people who actually, are interested in it. What if it's not because I was good enough, So yet again, I started, feeling unworthy. I started feeling like, why am I even doing this, And then I had 2 choices. It's either I shied away from it or I actually went on and checked up what was happening. So what do? I checked up what was happening and I went in. our very, very first meeting as a team was on the 29th of July. That day was something else, considering the fact that I am a person who is not verbally articulate, if I can put it like that. So when I went into this meeting and I was faced with people by the likes of Toshante and all of these people who are so verbally articulate, it was very intimidating for me. I felt like these people are not in my league, these people, I'm not on their level. What am I even doing here? And it actually goes back to what Herman said, that mooting is not about how you can speak, it's what you speak, right? So at that point, I'm already intimidated by my team members at that point. I want to say that these people are so good. Like, there's no way in which I can compete with these people. But I decided to, put that aside, and I was like, you know what, I'm deserving to be in this team. And by that, I mean that I'm going to perform, as a teammate. I'm going to do what I'm supposed to do as a team member. That means that I had to attend all the meetings. I had to be very, very participative in those meetings. I had to be intentional about being in that team. And that was very helpful for me and my team members as well. Why? Because when you have that mindset of being a team player, you guys actually, you're putting yourself at a benefit in general. Kamkhalo, can you still hear me? Kamkhalo? Okay, I'm sorry, because it's glitching this side. Okay, so that's what I had to do, and it was very beneficial for me. And this is the next very important point that I wanted to state to everybody. That as much as mooting is about you giving your heads of arguments that are very impressive, you being able to actually verbally articulate it or present it orally, teamwork is very, very important. It's essential for it, because you're not there as an individual, you're there as a team. So that means that your team members, no matter how verbally articulated they are or how well they know how to do their legal research, you guys are all a team. You guys are not competitors, you are companions. So you work together. Everybody needs to be allocated a certain responsibility as a team. Stay on the same page, stay on course all the time. Okay. I'm a person who believes in helping other people carry their burdens, but I'm very, very strict when it comes to responsibility. For example, if you see that one of your teammates is a person who has problems with buying data, for example, in order to attend the meetings or even do legal research, and you know that you have the ability to actually help them in that regard, do it. Help them in that regard. Be a team player at all times. Another point that I would like to say, because I see now my time is almost up, is the fact that the legal behemoth is going to be of paramount importance and support to you. But that does not mean that you now put all your baggage onto them. Remember, legal behemoth is made out of law students, not only in first years, but in higher levels of study, in the higher years of study. That means they have their own challenges that they need to face. They have other commitments, academic commitments that they need to attend to. So this is your journey. Make it about you. Okay, if you see that they are not there to support you, because we will be there, we will support you, but at times the cause is going to child this side. So make it about your journey. Okay, make it a point that whenever you know that you can go the extra mile, do it. And that's going to be beneficial for you as a person who's going to be a participant in competitions, and also your team in overall, right? So please, guys, always remember that teamwork is important. Yourself, your mindset is important. Enter these competitions, participate in them. Don't take yourself lightly, and enjoy it. This is going to be very nice for you. This is going to be a really nice experience. So enjoy it in the midst of everything. But that's all. Since I see Kamokelo, that's all from me. Thank you very, very much.
Thank you so much, Tobeka Noma Dlamini. There's someone, guys, I'm good at pointing out who's. Tobeka, please switch off your mic. You're distracting me. Thank you very much. Thank you so much, Tobeka Noma Dlamini. I think I need to fire you before you take my position as the junior moot of the executive executive committee of the legal behemoth. Thank you so much for your words of encouragement. I think the students have heard so much of every single thing that you said. I am going to quote a very, 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 very a very well-known scholar. It's Maya Angelou, and the quote reads, "Ilwan Tombo." I don't know if you guys have heard her say it in that American accent, like "Ilwan Tombo." Yes, that was Maya Angelou saying that you should fight, girl power, boy power, Ilwan Tombo, guys. So let us fight on and let us support each other while doing the junior mids. Right now, I'm going to give. I was supposed to give it to Tyler Chafter, but I can see that Tyler Chafter is not in because he is having connectivity issues. So he is just going to draft his speech for us in Word, and we'll distribute it to the students that are interested, especially in participating into the Moot Court competition. I'm grateful for all the speakers. I will now give it over. My job is done. And we are on time. Am I not excited? We are on time. So, the flame is here. So I will move it over to Overking to give us the closing and the vote of thanks. Thank you, everyone. Thank you so much.
Good afternoon, everyone. Can you see and hear me? Please just confirm with me.
I could definitely see you, and I can hear you now.
All right, thank you so much. Just a brief introduction. I am Obakeng Mulimi, and I'm currently serving as the Vice Chairperson for Legal Behemoth. I must say, I think this training really did serve with a lot of insight, with not only the importance of mooting competitions and just the culture of court, but also the fundamental elements and practical aspects of the competition and just how we carry ourselves in the court. And that is something that's very important to Legal Behemoth, because that is a culture which we uphold and value very, very seriously. So I'm a woman of very little words, and I'm not going to take a lot of time. I just want to thank our speakers. So Mr. Rawson, thank you very much for briefly telling us about the plans of UFS with regards to mooting competitions and just also the importance of mooting and the moot competition and participating in such competitions. And Ms. Berta for introduction that you gave earlier on. Also to our speakers for taking time out of their days as Candace attorneys and addressing us, Ms. Fisher as well as Mr. Durant, and not forgetting our EC, Ms. Durant, as well as Ms. Lamini for giving a brief explanation on the experience. And I think it's very important that they came on and just told our junior students what to expect. With that being said, I'd also like to acknowledge Kamogelo Mashego. We are extremely lucky to have you as the EC for Junior Moot. We are delighted and grateful. Thank you so much for organizing as well as facilitating this. It was a success. It was amazing. And we kept to time, which is beautiful. Also to each and everyone that is in attendance, thank you so much for coming. And I believe that it is something that's going to benefit you as law students as well as future legal practitioners, because I know it will benefit me as well. Thank you.